This is the plaintiff, Maureen Mays. She says her 15-year-old son's a competitive dancer who came in third at nationals last year, and she hired the defendant, a choreographer, to teach him a number for this year's nationals. She paid him, and he was supposed to send her son a video of the choreography to learn. When they got the video, it was amazingly awful. She's shocked the defendant acted in such an unprofessional way. She had to scramble at the last minute, and she's here seeking the return of her $500, the amount she paid. This is the defendant, Trey Roundtree. He says the plaintiff's one of those stressed-out dance moms who overreacted to the instructional video he sent her son. He's used to these moms, but he's been professionally choreographing for 4 years. He knows what he's doing, and if the plaintiff didn't like the dance he created because he was standing around too much, that's her problem. He's accused of not getting the steps right.
All parties, please raise your right hand.
Welcome back to the People's Court. Next case in the docket. The plaintiff's 15-year-old son is a competitive dancer who placed in the nationals. So his mom hires this choreographer to do a routine for him, and it says it's awful. Now, the defendant says the plaintiff's a stressed-out dance mom. It's the case of, I'm not a regular mom, I am a dance mom.
Thank you, Douglas.
You're welcome,
Maureen Mays, you are suing Trey Roundtree for $500 that you paid him for a choreography video that, according to you, was not what you requested. Tell me what's going on. How do you two know each other?
Mr. Roundtree was a professional assistant dancer for a national touring company. At the same time, my son was a pre-professional unpaid assistant in the same company, and they met twice. They danced together twice in November of 2017.
So your son is a dancer?
Yes.
How old is he?
15.
Okay. And he competes nationally?
Locally and nationally.
Okay. And how good is he?
Pretty good.
Came in third place in nationals?
Third in his age group last year for nationals.
That's fantastic.
Yeah.
Because this is a pretty competitive arena.
Yeah.
All right. So you, apparently you had helped out Mr. Roundtree on a prior occasion on something completely separate.
Correct. In the last fall of 18, my son came to me and had seen on Instagram that Mr. Roundtree had a coronary defect, a hypertrophic cardiomyopathy, an enlarged heart, according to his posts on Instagram. My son was very upset by this because he found Mr. Roundtree one of his mentors. He really enjoyed dancing with him. And so I reached out and said, hey, do you have health insurance? How are you getting help with this? It's really important that you get in and get medical care. He informed me that he didn't have health insurance, and so I got his information and tried to help him get Medi-Cal state health insurance in California.
Okay, so sometime later, how much later?
6 months.
6 months later, you
Yes.
reach out to him and tell him what?
We need a new solo for his national competition. He has one, but he needs one in a different genre. Would you be interested in choreographing that? I sent him an email outlining what I would like in the video with, for example, what I expected as far as mailing us an instructional video, going back and forth with video of my son doing his choreography with correction, etc. And he agreed and said that would be no problem.
Okay, he tells you it'll be how much?
$500.
So you paid a total of $500 for the instructional video?
Correct.
And then you received the instructional video, supposedly how long after that payment?
Quite some time after. We
Okay.
had a series of text messages back and forth. He had promised the video multiple times. On May 14th, I said that I had to pull the video. I had already entered it.
When you say entered it, you mean filled out the forms saying the genre is this, the time duration is this, that's what you mean?
Correct, uploading it to the national competition.
Right.
And paying the fee.
When
of
you say uploading it, you just mean the information that he had given you because you still hadn't seen the instructional video.
Correct.
Okay.
Oh, I wouldn't be uploading the instructional video. I would only be uploading the music.
I'm just clarifying.
Yeah, I would be, but I was supposed to upload the music as well.
All right. What excuses was he giving you between April 20th and May 14th? About
A
what?
lot of them. His wisdom teeth hurt. His wisdom teeth have really been killing me. My guy, I don't have the video. My guy who needs to do the video isn't here. I can get that tomorrow. So I got a lot of tomorrows and next Tuesday and next Wednesday. And each time, the day it was promised or the day after, I would text again, hey, still need the video.
Okay.
At one point, on May 14th, I texted him and said, I have to pull the video from competition because it's only a few weeks, 6 weeks before, and no shows are looked upon more unfavorably than not competing at all. And so I said I had to pull it. And later that night at 9:02, he produced a video that he sent me.
Okay, now this is the video that he sent.
In a world you've gone, few more years to go. Don't let the hurdle fall.
Okay, so far I'm watching you dancing.
Yes.
Is there ever a video you send with actual instruction?
No, because she kept asking me to send the dance video. She kept asking me to send the video.
Okay,
of the
did
dance
you
video.
ever compose an instructional video, which is what she had hired you to do?
No, because after I sent her that video, because I kept trying to send her the same dance video for the longest time. So after I sent her that video, she saw it. Then this is what she said. She said, "Thank you for your services," but basically she didn't want the
Okay,
video
because
anymore.
what she had asked you to do was an instructional video,
No,
right?
she didn't like the choreography. That's what it was.
Okay, let's see what an instructional video looks like.
That's not
You
an
had-
instructional video, though. It's not.
Yeah.
I just told you that.
So an instructional video looks like this.
Interact, we go counting forward, you're right. 7, we go step right, left, right, that'll be 8 and 1.
Okay, there's a bunch of talking in it. There's a bunch of instruction. I think we
Yeah.
get the general idea. So when he sends you a video of him dancing, what was it you said to him?
I said, thank you for your service. I can't use this. I need an instructional video.
And what did he say?
I don't believe he responded.
Okay, Mr. Roundtree, I'm trying to understand your defense. Are you saying that you know that's not an instructional video and that you were showing her the final product to see if she liked it to then create an instructional video? I'm not following.
So I was creating the dance video first, and I was going to send it to her to see if she liked the choreography. Then I sent it to her, then she didn't like it, and then she didn't even say choreograph something else. She said she didn't like it. Thank you for your services. And
Okay,
I offered
can
that
I
I would
see
choreograph something
proof of what you just said?
I don't know if it's in text or email or Instagram. She's messaged me off a lot.
May I?
Yeah. Did you ever tell him, I don't like that dance?
You can read it.
Okay.
It's the long paragraph.
So I see that for days you've been asking him to please send it.
Yes.
Do you want to
Just
see this?
send, why did you say send $550 via Cash App?
I had given him an extra $50 at the beginning. I
No.
did not want that back.
No.
I did not file
Stop
for that.
talking.
She's lying.
Do you mind?
So if somebody has health problems where they can't perform the contract, is that an excuse?
Yeah, I think that's the only excuse you can have if you're unable to work. I mean, you can't do it, so.
You buying what he's saying?
I am. I would say it could be an excuse if it's serious and you can do your work properly, yeah.
So it's an excuse not to perform under the contract if you got a serious health problem.
It depends how severe.
Does it? Does it?
Yes, and I think that if there is a severe health problem, he or she should have a replacement.
We will find out about this going inside the courtroom.
You write, and this is on May 14th, at 9 p.m., just send $550 via Cash App if you don't have the choreography. I'm done. I may look like some stupid cracker, but I'm not. Make this happen. Our young dancer is depending on you. You gave him your word. This is BS. Figure it out. He writes, what are you talking about? And then he sends the video. And he says, I've been trying to send him the video for days. I sent it days ago via email. Someone stole my phone. I apologize, but I'm trying to send the video. Then you respond, bottom line, no video. You've been promising it for a few weeks. I'm a mama, and this is my kid's future. You have our email. It works fine. I'm driving home now. I'll let you know if it's in my mailbox when I get there. It's not personal. It's business. He responds, I understand, I'm not taking this personal at all. I sent it a couple of days ago. I guess it didn't work. I sent it 3 times. I guess it didn't work. Then you say, video came in. Thank you. We won't be able to use it. We appreciate your effort. All the best to you. He asks, why won't you be able to use it? To which you respond, the moving parts are fine, but it doesn't tell a story, and there's a lot of walking around. I sent you a bunch of videos so you could see his style. That didn't happen. Also, I specifically said contemporary with a lot of hip-hop elements. That's why I chose you. It's fine. No hard feelings. Thanks for the effort. We will figure something out. To which he responds, but I'd have to direct him on what to do in his own style. And you say, it's just a mess. $550, lesson learned. John is heartbroken. Just forget it. He says, do you want me to choreograph it over and send a new version tomorrow? And you point out, I told you this last month, because we're getting very close to the wire at this point. He says, well, I must have forgot because I was waiting on an email. I'm sorry. I was just super busy last month, ended up homeless, so I was dealing with a lot. Then you respond, you were his first pro hero. The good news is that 2 years has passed and now he gets the business way better. You should have declined the gig and not accepted the money. That is how the real world works. Someone pays you and you deliver as promised. Having said that, I expect nothing at this point. You've got your $550. I'm willing to learn a hard lesson. We have until Sunday at 10 a.m. to cancel his solo and lose more money for canceling. You decide what's right between you and your higher power. I'm going to make dinner. And then you hear nothing from him in a couple of days. So you say, guess you and your God are moving on since you didn't reply. Should I cancel now or wait until Sunday? You wait another day. He doesn't respond. Then you say, not to mention all the time I spent trying to help you get insurance. Great dancer, not a good man or a good mentor. He responds to you, what's funny is I just finished the new choreography, but you want to sit over here and talk to me because I didn't respond like you know what's going on with me. And for days you keep saying, it's after 10 p.m. on Saturday. Should I expect nothing? Should I expect nothing? Should I expect nothing? You keep texting him and he says, I read your message the first time. Why are you spamming me with the same message? I sent it already. Did you ever get a second thing? You tell him that's BS, and then he just stops answering you.
Because she's texting me and messaging me off every social media. So I'm not going to respond to all of that at one time now.
Yeah, but here's the thing. You were hired to do a job and you didn't do the job. What is the reason that you didn't?
Because I had things going on, and that's not a good reason, but that's just the reason that I have, honestly. And she told me, oh, it's okay because John can learn dances within 3 days. He learns dances from professional dancers
But it doesn't
all the time.
sound like she felt like it was okay. I'm reading all of her texts and emails where she is really telling you, come on, I need something. Even before everything hit the fan in the middle of May. Before that, I see her saying, I really need this from you and what's going on. And I see your excuses about I lost my password, I'm homeless, and all this other stuff. I'm ordering you to return the $500. She couldn't use that. What ended up happening with your kid?
I've found a local choreographer who's 16. They're working on something now.
Okay.
She found somebody.
I find in favor of the plaintiff, pay the lady back $500.
Thank you.
So the plaintiff, or rather the defendant's going to have to give the plaintiff $500. You're laughing.
Yes.
Why?
Because this is hysterical.
What's funny?
Everything about this.
And you lost.
Yes, that's great.
Good luck to you. Okay.
Good luck
But you don't look so hot here right now, unfortunately.
I look great. You look great too.
Okay, very good. Thank you. It's over. All right. Ms. Mays, you could hold that. Oh, well. Okay, come on over.
Hi.
What are you thinking?
Well, it went out the way I thought it would.
Really?
But yeah, he, made a promise that he couldn't keep and devastated a young boy, and I'm just really glad that it went the way it should have.
All right. Well, good luck to him.
Thank you
All
so
right?
much.
I hope you've learned from this.
Yes.
I think you have. I think you have, for sure. Harvey?
Number one, a health problem is not an excuse for breaching a contract. It's sad, but it's not an excuse. And by the way, right time is of the essence if time really matters on the contract. Those are magic words.
This is the plaintiff, Dominique DeRocco Franklin. He says he was hired to choreograph a music video for the defendant, and they shot it in Miami. After everything was done, he never got paid, and the defendant's response was, she's having problems. Well, the defendant's problems are not his problems, and he has no other choice but to sue for the $1,600 he's owed. This is the defendant, Kalyani. She says the plaintiff is unfortunately suing the wrong people. She was only the middleman on this production. She's not responsible for paying this man. It's unfortunate he wasn't paid by the artist who hired him, and she expects the judge to agree with her assessment of the situation. She's accused of stiffing a choreographer, but good.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff hired the defendant to choreograph a music video and says the woman stiffed him. But the defendant claims she didn't hire the plaintiff, the star of the music video did, and that's who he should be chasing. It's the case of I Want My MTV.
Thank you, Doug.
You're welcome.
Okay, Dominique DeRocco Franklin, you are suing Kalyani and her company for $1,600 that you say they owe you and have not paid you. Can you tell me what happened here?
Basically, on November 20th, I was contacted by Dancers Gallery, where I teach on Wednesdays, about a gig opportunity.
Okay,
So we basically
and that's in 2020?
Yes, correct.
Okay.
And then we had pretty much less than 2 weeks to prepare choreography for a music video for an artist named Jimbo Lever.
Okay.
I never met the artist myself, but I gathered 6 dancers from across Broward County in Miami, Florida, and we was able to put it together before December 4th, where the video was shot in Miami, Florida.
Okay, and what was your job? To choreograph how many minutes?
It was I believe it was a 3-minute piece.
Okay, and then what were you going to be paid for choreographing it?
The agreed amount was $1,000.
And then the dancers were going to be paid what?
It was $150 each, but it went overtime, so we were promised overtime pay for the dancers. Okay.
Kalyani, do you have a contract? Does your company have a contract with the plaintiff?
Yes.
And what does that contract say? It says a lot of things, but what does it say about who's supposed to pay him?
The client artist.
Where does it say that?
One moment. Okay. Production agreement. It says here, production agreement. It says, due to the special terms of this agreement, all funds must be paid up front. The total amount due for the music video for the song Title Authority is $2,500. It says 1 full production date equaling to 10 production hours. I don't see here about the artist.
Right. Neither do
Give
I.
me one. Let me check.
While you're looking for that, let me talk to you. You gave me some video that I wanted to look at. Is this what? Okay, tell me what. Hold on a second, Kalyani. Don't talk. Hold on. What is that?
That's a clip of the dancers after they completed the shoot with the artist. The artist is in the bottom left.
Yeah.
With the black.
This is during practice, I guess?
Yeah, that was on the set.
Yeah. But practice, right?
Correct.
Right. All right. So are you reading the contract for the first time, Kalyani?
No, I've reviewed it before, and I've seen that I see it on here. The artist is, required to pay all of the.
Okay, so show me what clause to look at that says the artist is supposed to pay the plaintiff. Show me where I look for that.
Okay. So, kind of towards the bottom, it says all other needs, wants, and requirements to be provided by the artist or representative of the client. Say that again.
All other?
All other needs.
Yeah. How does that mean that this need, which is what you hired him for, is supposed to be paid by the artist? Because, see, I have a crew member agreement where it is clearly between your company and him. That's exactly how it is. Shall render services, and not only that, shall render such services exclusively to your company. I mean, you couldn't be more clear that it's your company. In fact, if anything, what your contract shows is the exact opposite of what you're arguing here, that the artist is supposed to pay. So tell me what clause I should look at that says the artist is responsible for paying him his $1,000 or paying the dancers.
The agreement is between the client and the artist.
No, it's not. Who's coaching you to say that? Whose voice am I hearing coaching you to say that? Why don't you make him come on air? Who is that? Because what he's telling you is false. The agreement is between your company and him. So it's exactly the opposite of what you're saying. So why don't you make him hold the bag on national television? Who is that?
Agreement
It's one or the other, folks. Either you are testifying or he is testifying. Who wants to testify? Call it.
Would he be able to do it over the phone?
Sure.
Okay. All right.
So get him on the phone, but he's got to be sworn in, and I want to hear directly from him what he's saying, and I don't want him leaving you holding the bag. Go ahead.
Okay. Okay, so he said he cannot.
Yeah, I bet he can't. Because now I'm going to read to you the contract that he claimed to you said one thing, but you got eyeballs and you can read, right? What does it say?
Yeah.
It says a contractor shall render, that's him, render services hereunder from the start date, blah, 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 and shall render such services exclusively to, and then it names your film company, right? And then it says that everything belongs to your film company.
Question.
No, I'm talking now. Then it says, contractor acknowledges that the contractor's work is a work made for hire, and therefore your company shall be the author and copyright owner of all of the work. And then it says that the two parties to the contract, your company and he, agree to arbitrate. And then it says, this is the entire agreement. So where do you want me to see the words, we don't have to pay him? That's between him and the artist. See, because what happened is the artist stiffed you, right? Right, Caliani?
Yes.
Yeah.
Yes.
And now that's a you problem, but you want to make it a DeRocco Franklin problem. And he doesn't want you to make it because his contract is with you, which is exactly what my eyeballs are telling me. So tell me where in this contract to see that the artist has to pay him. Where's that again?
There's a contract agreement between the artist and the client as well.
You say there's another contract. Is there a second contract, Mr. DeRocco Franklin?
Not to my knowledge.
Okay, why don't you provide the second contract that says something completely different from the first contract? Show me that, Ms. Caliani.
Alrighty. One sec. Addendum. Okay. The artist agreement. I'm trying to look for it.
You know, it's kind of the only thing this case is about. So you had to know this was going to come up.
Okay. I have the agreement right here. Artist production agreement.
Right. That's the agreement between the artist and you, isn't it?
Mm-hmm.
Yeah, where the artist talks.
Yeah.
Right. So that's the one you get to go to a court and sue for.
Okay.
Right. Where the
She's
artist
reading,
has to
okay.
pay you, but he's not privy to that contract, is he?
Did you review the production agreement between us and the artist, or
I
just
don't
the
care. Why would I care about that? That's not what he's coming to court and suing. I know the artist owes you money. That's a you problem. How does that become a him problem?
Because the artist chose him. What happened was we chose the first.
No. Show me a contract that he signs where he says he's going to get his money from the artist. Do you have that? Because that's what you say you have. And that's not what you have, is it? You have a contract where the artist is supposed to pay you money. And then that went south, and now you want to make that his problem. How do you figure? So again, I ask you for the last time, do you have a contract between him and the artist that says that he is expecting to be paid by the artist? He is expecting to be paid by the artist. Do you have that?
I don't have that.
Right, you
but
don't.
But it makes it clear that the client is responsible for hiring and payment of the crew.
Okay, well, you do read, right? So you see that the contract I read out loud is a contract between you and him, and that's what he's suing on. Your company owes him money. Yeah, that's your contract. That's the only one he's ever signed. He's never signed anything else. You're literally arguing to me, yeah, but I don't have the money because someone owes me money. That's what you're arguing to me. That is not a legal premise. But the worst part of this, I don't know what the fellow who can't be bothered to come to court, who's telling you what to say is to you, but you got to rethink that whole relationship with him, whether it's business or otherwise, because he has completely left you looking like a fool, hasn't he? Mm-hmm. $1,600 verdict for Mr. DeRocco Franklin.
So the plaintiff is going to get his money after all. Ms. Caliani, let me ask you, are you at all surprised by the judge's decision here? Or did you learn something while you were reading the contract with her?
No, not surprised.
What are your thoughts right now?
I was doing a favor. So I work closely with the company. So it's okay.
Well, it's not okay. It's the guy who's talking to you in the background, I guess, who really is the main culprit here. Mr. Franklin, Director Franklin, was it a worthwhile project to work on? How'd it work out? It looks like you were shooting at a football stadium, were you?
Yes, the dancers actually enjoyed it, but it was nice. It's just that was the only issue I had, was not getting paid as a choreographer.
Yeah. Did it ever see the light of day? Not
to my knowledge. I haven't seen it on social media or YouTube.
Yeah, okay. All right. Well, I hope you've learned something from this, but hey, look, you had a valid contract. There wasn't anything else you could do but sue them, and you did the right things. So congratulations. Okay?
Thank you.
All right, Harvey.
So, Doug, look, this is why written contracts are so valuable. That if you had an oral contract, one person says one thing and no, that wasn't said. The other person says something else was said. Here, both people have the same document in writing with the same terms. Easy for the judge to figure out. That's the way to go.
How come there isn't an implied warranty of merchantability applied when you buy a used car and it breaks down the same day? I see a lot of used car disputes on your show.
Yeah, people, I often get this question because people think that's really unfair. If I just bought it today, I should be able to give it back to you. But then what if you just bought it yesterday? Should you be able to give it? What if you just bought it last week? Should you be able to give it? The problem is that we have commerce going, and it's the law in its infinite wisdom has decided that if you're just a guy selling your car,
not a dealer,
you don't know what you don't know.
Right.
So we need to keep commerce moving.
Every time a car breaks down.
Every time a car breaks down, you're going to sue.
There's one thing we all know: cars are going to break down.
They're going to break down
at the worst possible moment, usually. Right.
So the presumption is it's as is unless you warrant something. That means you know darn well that engine is 12 years old, but you say it's 1 year old. Well, you're lying. Now there's something you did, and that is actionable.
You're stepping into the realm of fraud.
Right.
Which is not easy to prove normally.
Right.
But if you.
But I have had cases where a guy will say, this engine's great. There's nothing wrong with the engine. And then the new owner takes it to the same mechanic who the old owner took it to, said, I told this guy this engine was going to die the next day.
Right.
And then all of a sudden that guy had some problems. But generally speaking, it's in an effort to keep commerce flowing because there's just too many used car sales and people don't know what they don't know about what will happen in the future. We don't hold them to the standard that we hold dealerships or used car dealerships, which, every state has some laws about what they must warrant and what they needn't warrant depending on the mileage, et cetera.
Right. So generally speaking, you're not going to get anywhere unless someone sold you something that's obviously unsafe. And then it's who's to say who's obviously unsafe. The one thing people do get win in litigation on this kind of thing is when they can't provide a title, because that is the one thing you're warranting, that it's a car that you can register. It's not a tennis racket.
It's not right. It's a car, and therefore you have to be able to register it.
Right.
So thanks for joining us. We will see you for the next session of People's Court.